On today's episode of TR Legal Briefs, I would like to discuss with you standardized field sobriety testing in a DUI case. My single best piece of advice to you is don't do roadside field sobriety tests. After the officer pulls you over, for whatever reason that is, whether it's speeding, swerving, improper lane change, tail lights, whatever the case may be, they're looking for evidence to be able to arrest you for driving under the influence. The way they get this evidence is to ask you to submit to field sobriety tests. Then when you fail, they can arrest you for a DUI. What they do not tell you is that you don't have to do these things. It is not mandatory to do them. Therefore, you should not do them because you're literally giving the police officer the evidence to arrest you for a DUI when you do them. Now, let me talk to you a little bit about standardized field sobriety tests as opposed to what officers actually do in many of these situations. There are 3 standardized field sobriety tests, and this is according to the National Highway Traffic Safety Administration. There is the horizontal gaze nystagmus, there is the walk and turn, and there's the one-leg stand. Officers often ask you to perform different tests that are non-standardized, like recite the alphabet backwards, touch your finger to your nose. Those are a couple of the common ones, but just so you know, those are not standardized. So the officer is not going with the training that he's likely gotten or she's likely gotten if they don't ask you to submit to standardized field sobriety tests. That being said, field sobriety tests are accurate approximately 70% of the time, depending on which test you're doing. This is why it's so important to just not do them. You don't have to. Now, if you're under arrest and the officer asks you to submit to a chemical test at the station or at the hospital, then you want to think twice about refusing. If you refuse a chemical test after you've been under arrest, then you're going to have more serious penalties that actually don't come from the criminal court. They come from PennDOT, which means even if you are not convicted or you're found not guilty of a DUI, you can still get a significant license suspension by virtue of having refused to take the chemical test. And this is because when you sign to get your license, you are in essence consenting that if an officer has a reasonable suspicion of DUI, you will go ahead and take the test. Then when you refuse, you have that enhanced suspension penalty. We can fight that too, but that's a lot more difficult. If you found yourself in a situation where you've been charged with a DUI, whether it's a first, second, third, please make sure you contact us immediately. There are many things that can be done. You need to make sure you have an attorney that knows what they're doing as far as standardized field sobriety testing and what the officer is supposed to do. And we have specialized training here at Tibbott and Richardson to be able to help you do that. So if you have any questions, please give us a call. We'd be happy to give you a free case evaluation. Thank you.